replay. We're also live streaming on TVW. So with that, I'd like to welcome our moderator of our esteemed panel, Leah Salerno with Disability Rights Washington.
Hi, everyone. Thank you all for attending. My name is Leah Salerno, and I am an attorney with Disability Rights Washington, and I have the honor of moderating the panel today. I do want to say that if you have questions throughout, we will, if there's time at the end of the panel, we will try to go through some questions, but no guarantee that there will be time as there's a lot to discuss today. So as everyone is turning on their cameras, as we get started, I just wanted to say that so each one of our panelists lives at a different space regarding intersections of race and disability, and I'm going to call on each of our panelists individually to introduce themselves, and could you each speak to your personal or lived experience with race and disability when calling you. So let's start with Justice Whitener.
Good morning, everyone. I am Justice Helen Whitener. I sit on the Washington State Supreme Court. I was appointed last year by Governor Inslee and then retained by the citizenry of Washington State last November. I'm Washington State's first Black female Supreme Court Justice. I am its fourth immigrant born. I am also the only openly gay Black LGBT judge in the state of Washington, and with my appointment last year, I became the first in the nation that sits on a Supreme Court. I identify as someone with a disability as well. So I have many intersecting labels, and I look forward to the discussion this morning. Thank you.
Thank you, Justice Whitener. Judge Galvan, would you like to introduce yourself, please?
Good morning, I'm Veronica Galvan. I am a King County Superior Court judge. And while I do not identify as with any disability, I do teach in the space of bias and racism and in that area. So I'm looking forward to this discussion today and looking forward to talking to everyone.
Thank you. And Ms. Basas?
Hi, I'm Kiri Basis, she, her pronouns. I am going to provide an audio description for access purposes. So if someone's wondering why I'm describing what I look like in an awkward moment, it is for access reasons and not for anything else. I have blondish brown graying hair. I'm pale skinned. I'm a white woman of mixed race ancestry. I have a pinkish peaches blazer on with a black linen top and a beaded necklace. Justice Whitener and I are rocking a similar color today. And I have a bookcase behind me. And I also wanted to point out for access that you can, if you're on the Zoom call, can do the live transcript, closed captioning at the bottom. And I'll make sure to say my name every time before I speak. So I also want to acknowledge that I'm on the land of the Coast Salish people as the education ombuds under the governor's office. Our relationship is so important to the tribal nations in Washington. And this is unceded land that we do our work on, and we learn from the incredible wisdom of the tribes. So I, as I mentioned, am the director of the governor's office of the education ombuds. I grew up in separate or segregated special education until third grade. I have multiple disabilities, and what I really saw in my education experience and really drove me to this work from a lawyer to now in this ombuds role is seeing how many kids of color and working class kids with disabilities were put in separate schools. So I'm really excited to join the rest of the panel today. And please let us know in the chat if you have other access needs that or in Q&A that come up.
Right. This is Leah, and thank you, Ms. Bassis, for the reminder to say who we are before speaking. Uh, so I also wanted to introduce myself briefly. So I am an attorney with Disability Rights Washington, and I have multiple disabilities. I have had different disabilities throughout my life, including having some accommodations throughout school. And so my experience is different from that of all the other panelists, but somewhat similar. So I think that is going to make for a great panel. So thank you all for introducing yourself. Okay, so since we're talking about race and disability, to help ensure we all have a strong foundation for today's conversation, Justice Whitener, could you define intersectionality for the group just a little briefly?
Sure. Keeping in mind that part of this definition I've honed to address all of mine, but it's a phrase that was coined, a term that was coined by Kimberly Crenshaw, who is a professor as well as a civil rights advocate. And when she coined the phrase intersectionality, it was to address a situation in regards to Black women and discrimination. To point out to the court that there was a difference in regards to how Black women access different things and how we're viewed and termed differently. Since then, and I think that was in the 80s, but since then, it has been used a little more expansively to encompass the intersection, the crossroads, so to speak, of different labels. And the labels are usually disenfranchising or marginalizing labels, and how those labels, where they intersect, and how that impacts access to opportunities and services. Another way of looking at it is the way I, as a Black woman, transverse through this world is a little different than another Black woman who doesn't have all of the different other marginalizations that I have, as I've indicated, LGBT, someone who identifies with a disability, because some of them are obvious, but some are not. So it is taken into account how those different intersecting labels, societal disenfranchising, oppressive labels, intersect and the impact that has on the ability to access opportunities and services. And that's how I would define it for this morning session.
Thank you. I think that's a great.
Justice Whitener, can you move closer to your microphone, please? The audience can't hear you well. Thank you.
Thanks. Usually folks want me to step back, but I'll step forward. Is that any better?
Yes, it is. Thank you.
All right. Thank you.
Great. Thank you. So this is Leah again, and moving on. So the other foundational question is going to go to Ms. Basas. You have a long career as an advocate and educator on disability law. Could you help us understand the difference between disability justice and disability rights? And then which frameworks do you think is most reflected in our legal system and why?
Yeah, thank you. And thank you for Justice Whitener for teeing up the conversation around intersectionality. This is Carrie, and it just feeds so well into a conversation about disability justice. So disability rights is the framework that most of us, our lawyers, are trained under. It's a civil rights model where we see that the law is the tool for curing everything or a lot of things, that it's our strongest tool to move towards justice. And it looks at things like access, ramps, communication access, non-discrimination and employment. A disability justice model, however, came about through the work of the most marginalized people in the disabled community. So cross disability, BIPOC, queer, artists and activists who said the law isn't everything. In fact, we haven't seen huge shifts in employment for disabled people since 31 years ago when the ADA was, the Americans with Disabilities Act was enacted. And really the best solutions come out of working cross disability, cross movement, being humble and acknowledging that the disability movement itself has marginalized and oppressed and reenacted racism, anti-Blackness, homophobia, xenophobia within its own organizing. Disability rights, there's a great Twitter thread. You can look disability rights, so white, or there's some under disability rights too white. It is really a movement in which the contributions of people of color and queer people with disabilities, people with mental health disabilities that are more stigmatized has been erased. They were there. I have a poster of the great activist Anita Cameron behind me, who was Black and queer and worked for things like the Americans with Disabilities Act and transportation access and healthcare access, but she's not often told as part of the story. So you could look up the principles, I won't go through them, that came up under the disability justice framework. There are 10, but I just wanted to highlight that it's really this idea of intersectional justice and realizing that we leave no one behind, that we don't play the misery poker of someone is more oppressed than another, and we acknowledge humbly the ways in which there's privilege even within the disability community that has oppressed and erased other people within it, because we reenact those isms within the work that we do. And I would say, perhaps I've already answered this question, that a disability rights model, we have, as an attorney, we have a little bit of arrogance about the tools that we have and probably a false sense of confidence about all the things they can do. Disability justice would say, those tools are great, keep doing them. We want you to fight the fight, but we want you to do it grounded in community and realize that we have solutions as well, and that we should drive what the agenda is rather than you saying, as many of us do, and I'm guilty of it as well, this is a really interesting legal question to me, but might not have the biggest impact. So thanks for setting that framework, Leah.
Thank you for that great overview. And so I wanted to shift now that we all have somewhat of a common framework to start with this morning. The COVID-19 crisis has revealed significant inequities in access to necessary healthcare, economic security, and access to government services. I'm going to first send this question to Justice Whitener and Judge Galvan. I will call on you each in turn, but how has the COVID-19 crisis impacted people accessing the courts? And what have the courts been doing to try to prevent disparities for people with disabilities or people of color in the impacts of COVID-19 upon access to the justice system? So I'll go first to Justice Whitener.
Well, since you heard from me, I think it'd be nice to hear from my colleague on the trial level court, Judge Galvan. Then I'll go next. You're on mute.
Sorry, I think the access question is different depending on which level of court you're at. Obviously, at the Superior Court, we still had in-person hearings for certain cases. We still, but what the COVID-19 crisis has done, I think, is systemically laid bare how we have failed people, how we have failed community as a system of justice, which is a humbling thought, because we're supposed to be about justice, and we have failed in allowing people to access it fully using the means that we have at our disposal. I can say that we have made generational changes and shifts in how people access our courts that is due to the pandemic. We shifted to models where we allowed for telephonic access for individuals, electronic signatures, no signatures, where we allowed people to access things remotely via the platform Zoom or WebEx in some courts. So we learned that we could allow people greater access, and we learned that the sky wouldn't fall. But we also learned is that not everybody has access to those tools. So it also laid bare the inequities socially of what people are able and capable of accessing. So it seems that every time we peel back a layer and think that we're doing good, we reveal yet another set of places where privilege exists and the other side of the coin, oppression. Now, I stated earlier that I myself do not identify with a disability, but I had a temporary one some years back that really gave me a different perspective. And those perspectives, and I think that consciousness is hard to come by when you don't experience it and you don't see it. And having not being able to use one of my legs for a while and having to go on a scooter for a while, it made me think about how hard it was just to physically move within spaces. So I think as the ADA Act 30 years ago, which we just celebrated on July, the Americans with Disabilities Act, which we just celebrated July 26th, I think it's important to acknowledge that for many, in many instances, for those disabilities which are physical in nature, we have been able to build buildings. I work at the Regional Justice Center in Kent, and I juxtapose that with the building that was built in the 1900s in downtown Seattle. And this building, people are able to access in different ways. Even our jury boxes are accessible, unlike in Seattle. So we have made progress, but there's so much more to go. And I think that we have to recognize that the intersection, particularly of race, when it overlays all of these other isms, has a completely different result for individuals as well. But in our courts, we continue to work on ensuring that people are able to access our courts in a way that they are, that they feel safe, secure, comfortable, and they feel that they've been seen and heard. It's a work in progress. We haven't perfected it, but we do acknowledge it, and we continue to seek advice and inform ourselves as to what we can do better.
And to add to that, I'm on the Office of Civil Legal Aid Committee. And what I was really happy to see is the community at large were being served in regards to civil matters. Criminal matters, most folks are familiar with that, but in regards to civil matters, because COVID, I think, put everyone on the same playing field in regards to finances. So you had individuals who lost their jobs that needed services, legal services. Folks were losing their homes, because if you lose your job, there's a trickle-down effect. We saw a spike in domestic violence because of the stay-at-home order. So folks were now stressed and under the same household. And so we saw numbers go up in regards to domestic violence, assault, and sexual assault. We also saw work being done by way of funding to assist these individuals being increased. And I think that's good, and I hope that continues, because most folks that utilize our court services are not coming before the court for criminal matters. They're coming before the court for civil matters. And funding was there before, but it wasn't adequate. I think COVID showed us how inadequate our funding system has been in regards to addressing civil matters and not just criminal matters. I do know the Office for Civil Legal Aid did a lot of work. And of course, they have those subcommittees, stakeholders that assist. But I was really impressed with how they stepped up, stepped in, and basically started trying to figure out how to plug some of these loopholes within our system in addressing civil needs. I think since we're talking about intersectionality, it's important to understand the way COVID impacted, for example, communities of color was quite different than it impacted the other communities, because it showed, one, a number of things in regards to access, but it also showed the distrust that a lot of these communities have with our courts. And our courts can't function well in regards to addressing access to justice if the community that it's serving can't even trust it in regards to legal issues. So that's something I think that the discourse that goes around now in regards to racist use is being addressed. I think a lot of discussion is not just race related. We're seeing that there's an intersectionality with race of other marginalized subgroups. But most importantly, I think in regards to the court is the socioeconomic disparities that we see amongst these different groups and how that has impacted their access to our courts and justice as they may define it. So I think there's been a lot of changes that I hope continues. Judge Galvan indicated on the trial level courts utilizing more telephonic communications, but the access in regards to technology and utilizing technology where you don't have people coming into court for mundane hearings when they could appear from wherever they're at by phone even, you know, on Zoom on the phone or something like that, for a court hearing, that they don't have to leave work, lose income to come into a court building to sit for hours. It really made the court and has made the court look at how we have been functioning in a technologically savvy environment and not utilizing it in the court. So I think COVID was terrible on our courts, don't get me wrong, because we have a tsunami of cases coming through and now we're dealing with the variant. But it has raised people's consciousness and understanding of the disparities that have been in our system for too long.
I just want to add, I want to piggyback on that. I think it taught us that we can meet people where they're at and we can still function. That is what is a lesson that's learned. It also taught us that systemically, not just the court, but other systems, education, healthcare, all of these other systems encountered the same issues and that they can also meet people where they're at. So this is a different perspective because COVID had different impacts on different communities and it just laid bare those disparities in a way that nothing else in my memory, and I'm sure there's obviously been pandemics before, there's been issues before, but it's certainly in my memory didn't lay it out. And I also want to say our systems look different today than they did 50 years ago. Justice Whitener and myself are two examples. You know, in our lifetime, we've had the first female judge here in Washington State. In our lifetime, we've had the first person of color judge in Washington State, and we have several at this time. And those perspectives and those prisms and those lenses, when we put it on some of these issues, give us different results. And I think we're seeing some of that, but there are still a lot of inequities that we have to deal with, but we have to have the humility to understand that we've inherited this and we have to own it now. And we have to try to work with the people that we serve, all of the people that we serve, to make it better.
This is Leah. Thank you both. And continuing on our discussion of COVID-19, Ms. Basas, how has the COVID-19 crisis impacted people accessing education and other governmental systems? What has been done to prevent disparities for people with disabilities and people of color and the impacts?
This is Carrie. I'm going to speak from the heart on this one because COVID is still with us, right? And in the past week or two, what we're even thinking about what education looks like, our legislative session, our court system, our administrative hearing system keeps changing. I would say there have been so many psychological and re-traumatizing impacts of COVID, first of all. When I was sitting in virtual disability justice communities, advice that was going out to disabled people, particularly disabled people of color, deaf people of color, was to write on their bodies with Sharpies if they had to go into the hospital that they wanted to live, because we know for people's safety that people were isolated during that time and they didn't necessarily have a set of eyes on them remotely or otherwise looking at whether or not their dignity was being honored. And we know there's such incredible bias in healthcare towards trans people, people of color, Indigenous people, disabled people. And so you bring that together and you see what that looks like, especially as we were looking at emergency rooms filling, discussions about healthcare rationing, limits on ventilators, and the rush that we had in the initial stages for people to get vaccinations when other people who are most vulnerable were kind of still waiting and other folks jumped the line. So when I think about education, I think that we haven't necessarily figured out how to prevent those disparities for people with disabilities or people of color as an institution. What I will say is that we had students with disabilities who came through our office, particularly multiply marginalized disabled students, who for the first time in their lives weren't bullied at school. We just ran our annual report data, and sort of a bit of dark humor for me to say, guess what? Bullying, which was our second biggest category, harassment, intimidation, bullying, is not there or is very small. I mean, I know cyberbullying exists. We saw disabled kids of color say that they felt more comfortable at home, that with their families, they could learn about Black history in a way that they did not learn about in the classroom, or they felt more comfortable because they weren't with ableist or racist teachers. And so that's the negative piece of it, right? And sort of the positive of it in there, but it tells you a lot about our school system. It also tells you a lot about resilience. We also saw students for whom those breaks between classes or the individualization that needed to happen and a smaller classroom instruction remote really helped to get the attention and the investment that they needed. I think it helped teachers, but they were also going through a crisis, just as all of our school leaders, support staff, and families were. What I thought was most beautiful in this was the ways in which, and we think about the limited capacity that people had, that individual teachers and principals and paraeducators reached out to families and tried to help them with issues like language access and technology and keeping on track with the school assignments, trying to ease some of that burden as they too were trying to support their own children or people in the community with those issues. And the strongest work around preventing disparities or addressing them for people with disabilities or people of color actually came from communities of mutual aid, whether it was parents coming together, disabled people coming together, or Somali parents coming together and trying to help each other navigate, these technological interfaces that were in English. Those were really amazing ways in which people saw one another and saw the needs and came together. I guess structurally, some of the things we became more attuned to were the punitive impacts of looking at things like attendance and siphoning people off pretty quickly to the juvenile justice system. We had to think differently about attendance. We had to think differently about what participation looks like and what it looks to achieve or be proficient. We lost some of the great enrichment activities that we would have normally. And I would say the social emotional impacts on students were great. Right now, there's so much that could be said, but right now what I'll end with is we have students who are reaching out to our office or their families where they are fundamentally different. I know we're all different, but here is a student that's mental health has been pretty good, right? But over the time of COVID, depending on the stressors that they experienced, any, intersecting health issues or experiences of discrimination or feeling particularly vulnerable, they have ended up hospitalized for mental health support. So trying to explain to a school system that maybe some of the procedures that you have where you tell a kid to come into the classroom and we'll observe them for a while and then decide if they need individual education program or a 504 accommodation is not really how it has to work, because we have students that have reached out and families where there are issues of self-harm that we can't really necessarily say, here's this process. And we'll also be struggling for quite some time around what are recovery services? What does it mean to try to, quote, make up lost time? And who has been most affected? We'll have to take data around that. We also have some real limitations, even with federal funding coming in, about what that will look like and when those services will happen. So I would say for a while, since people were under so much stress, our cases went down, but which is interesting, but the complexity of those cases went up exponentially. And I expect that it will continue in that way.
Thank you. This is Leah. So I know that the next question, all of you have touched on a little bit, but we'll see if there's more to add. As we look towards a different phase of the COVID-19 crisis, which I will acknowledge is, what we're looking at today is not what we thought we were looking at 2 weeks ago, yesterday. And so it's kind of hard to say if we're in a different phase or where we're at even. But as we're trying to look forward now, what lessons do you think our systems have learned to date, and what changes or adaptations instituted during the crisis should continue? And I'll actually start with this one because I haven't given much of my personal perspective here. I think one of the things that all of our panelists have highlighted is that our systems did their best to adapt, and that we learned things, that there were ways to accommodate things that we didn't think we could necessarily accommodate before. I think personally, I saw a lot of, working from home, and working from home, even outside of the legal system, was something that was an accommodation that was rare or rarer. And a lot of people, I think, learned that working from home could be an accommodation, as an example, but there were, lots of things of different ways we do meetings, different ways we connect with each other, that people weren't aware that they needed accommodations because they weren't aware how much they were struggling. And then once everyone was struggling in a way that we were not expected, I think that brought to bear a lot of the inequities and weaknesses in all of our systems. And so I think that there are a lot of people that may have even known or not known that they had a disability prior to COVID-19 and realized that, oh, I need accommodations because the system's not working for me. And this, the way we're doing things now might work better in some instances than others, such as, working from home or remote access. Of course, that does, I think we talked about the digital divide, and I think that is a huge issue that I like to see us address moving forward, because technology has been amazing for access for so many different marginalized communities, but it's only useful if you actually have access to technology. And we can only move forward with what we learn if it's equitable and everyone has access to the new knowledge and advancements. So I will leave it there, and I will ask if any of our panelists have something. I'll repeat the question since I spoke for a little while there. So as we're looking forward, what lessons, sorry, I lost my. What lessons do you think our systems have learned to date, and what changes or adaptations instituted during the crisis should continue? Judge Galvan or Justice.
Well, I can speak certainly from the court system perspective. We have learned a lot of lessons. We learned, for example, that we don't need to have as many hearings as we do, that it actually allows attorneys to work on their cases instead of spending time in a courtroom checking in. It's obviously King County specific in terms of the amount and types of hearings that we had. I think changes to 3.4, the rule that governed appearances in court, allowing people to appear through counsel like they would in a civil case for many hearings, making the court find what hearings are necessary, and being able to issue warrants kind of as a last resort, I think are important. Allowing for people to access the courts in a myriad of different ways that didn't require them to be here in person for many of those hearings. Allowing civil access to the filing of protection orders, to the Zoom hearings, to family law cases, to civil trials, all via Zoom, to having jurors in civil cases appear via Zoom and share electronic information with those jurors. A recent study here in King County indicates that our diversity of jurors increased as a result of allowing people to be jurors in this format. Because again, we weren't bringing everybody to the courthouse. They weren't missing an entire day of work. They had a time certain, a date certain, and they loved it. So the surveys that we've done and the information we've gotten back and the feedback we've gotten back from jurors who have served in this fashion has been incredible. In criminal cases, we've done a hybrid jury selection, bringing in only those jurors chosen for the case in person, but often choosing those jurors in this fashion. In most cases, some cases we haven't been able to do that for a variety of reasons. I think that what we've learned is that we didn't have all of the answers and that the status quo is not always neutral. I think intellectually, many of us have recognized that, particularly if you are BIPOC in America. We've always understood that the status quo has never been neutral. And I think for me, the justice system is probably the greatest representation of that, because if we think about history and how we deal in the law, our past informs our present. That's how justice in America has always worked. So when we ignore what has been done in the past, we continue to perpetuate certain isms into the present and onto the future. So that recognition and understanding is important as we look at what we're going to change. We look back and we see that there was a point in time where we had separate systems for everything. There were separate systems for education, separate systems for separate hospitals, separate businesses, neighborhoods, all of those things. And we know that that was not okay and wrong. But what we've never had in this country is a separate system of justice. So we've always believed that the status quo was a default. We've always been told that it was neutral. And we are learning, and I think that we know that that's not necessarily the case, which is why when we think about issues of diversity, it's not so much just having people in those places, it's about the diversity of their lived experiences and the lens that they bring to the problems that are pervasive in this country. Those lenses, those prisms are what allows us to progress, to be better, to actually put into practices some wonderful principles that we have to acknowledge have not always been practiced. So the principles of justice that we have put to paper, that we claim these are the principles by which we live, have not always been practiced in accordance with what philosophically they were intended to be. And I think that we have to hew to those. I think that there is wisdom in that. I think that there is opportunity in that. But I also think that we have to do it with the acknowledgement that we've failed in so many instances. I believe justice is one of the greatest inventions of humankind. But I also have to acknowledge, that the law has contributed to a lot of these isms. So if these are all social constructs, then the law has been a primary architect. And I think it's our job to understand that and humbly try to move forward and do better and be better. This is, I think, our calling. And I think everybody here understands that in the work that you do daily. And you have to keep pushing us, have to keep pushing these systems to live up to its promise.
I think for me, when if I remember your question correctly, what I think has come out of this is we've started looking at each other and understanding that even though we have differences, they need to be valued and acknowledged and understood. So the discussion has now started occurring. As Judge Galvan indicated, I think prior to COVID, everyone was on this diversity kick and they figured if they allowed one in, that was fine. And I think what they realize is you can have one in, one, whatever that one is, and it not be a very inclusive environment. People weren't being valued. They were just being, oh, there's one, there's the quota. We need to move on, they're in. The other thing I think COVID has shown a number of us is that there are more isms than racism, but racism is at the core of all of these issues. You have ableism. I lost the use of my right side at 16. Most of you know my story. That's why I came to the United States for medical reasons. And then my lens formulated in regards to ableism from that point forward, because prior to that, I ran track and I was very able-bodied. You're not seen. You're not considered. They speak over you, not with you, sometimes not even at you. Our court system is no different. And what happened with COVID is folks who otherwise were not considering viewing accommodations the way they needed to, they always saw it as giving you special treatment. Now they're beginning to understand, I guess, there by the grace of God go I, but they're understanding a bit more how to be a little more inclusive. And inclusion does not mean numbers or, groups. It means valuing, acknowledging the worth of the individual or groups that we're dealing with. So the changes that are being made need to address the systemic ism problems that our courts have not addressed over the years. So we're looking at things differently. We're hearing and having the conversations. There is a lot of backlash in regards to just sitting down and listening to people because it's being taken personally. It's not meant to be personal. We all come from different intersections and we're trying to have our voices be heard to address the problems within the system. And it's a systemic problem. But if you only look at it as the one ism that we've always dealt with, which is racism, and you don't address the other isms, then, for example, when we're dealing with disability, one group is always going to feel left out of that discussion. And at the end of the day, you will not address the ism because you never address racism and you're trying to address ableism. At the end of the day, they're intertwined, interconnected, and that's why I think it's important that we take that perspective moving forward. And COVID has started that discussion. Is having these structures that have been in place look within and figure out, well, wait a minute, we've fixed this before, and why do we have a problem now? Because you never took into account all of the other isms that intersect, and connect with the problem. So it is a problem, and that's why I like the fact that this was called race and disability, because at the end of the day, you got to address the racism, but you can't forget the disability as you do so. That's part of the discourse as well.
This is Carrie. I would love to just add to that and reinforce everything that has been said. I have so many conversations across community where the phrase that keeps coming up is, if not now, then when? What we saw, and I know the judge and justice pointed this out, is we saw incredible flexibility. Did it support everyone? No, it mostly supported people like us who have professional level jobs. There's access to court pieces are really important, but who could stay home? Lawyers, ombuds, judges, state agency directors, you know, and it wasn't the grocery store workers, it wasn't our healthcare, it wasn't the person who delivers your Amazon packages that allowed you to stay home and not go outside for your groceries. But with the if not now then, people are holding their breath saying how much of this will stick, and also how much of this can we grow towards a more just future for everyone, the people that we left out, because there's an incredible pull. And I say governments, legal systems are very, you know, we share this, that the people who have been in charge really have this idea of what was normal and what was comfortable. And so we saw that in the past few weeks. It's like people are very excited. Let's go back to in-person meetings. I love seeing your face. I don't want a mask on. I want to hug you. It's been pent up for a while, right? Let's move our chairs closer. That work is not really work unless I can see you. So as if this last year and a half has really been us, you know, twiddling our thumbs. And others that did benefit from this, or finally were seen because others had similar needs, are like, wait, I thought we were going to look at this, evaluate it, and see where we can move it forward. And there's so many wonderful leaders that we have in various parts of government, in our legal community, in our private sector. But one of the things that really needs to change is who's in charge. So that additive approach, as Justice Whitener brought up, just doesn't do it, because what we see is people are pushed out. They don't see other people like them. I didn't see other people like me in the legal profession, certainly not at Harvard Law School. And I thought that people like me couldn't be lawyers. I don't know that people like me can always be judges either. And we know that that's true for other communities as well. So unless we change who's in charge and give them the actual power to do that job in the way that others have held it closely, we're just going to have this tug of war in which people with the most traditional power win. They do, or at least it's going to be quite unstable in that way. So I would like to breathe a little bit and hope that things will look different. And I know that that need exists across community, and it hasn't been just the pandemic. We've just had growing awareness, whereas other people lived with it all the time, about racism as well during this time. And real interest and frustration, you know, among accomplices and people lived experience that things aren't moving forward as quickly, or that they might move backwards.
I do want to correct something here in King County, at least. Judges did not all judges were able to work from home. I know that I was here every day because of my assignment in a criminal courtroom. And if I'm going to be arraigning people who are present before me, I need to be there. Many times families, victims chose to come in person despite the offer of our technological attendance, and they wanted to see it. They wanted to be there and see justice happening. Our doors did not close, and they still haven't. What we offer are frankly options, and some of those options people aren't able to access, and we recognize that. I think many schools recognize that as they deployed buses to try to provide Wi-Fi to students, as they handed out tablets to students in schools. And those are the challenges that we face, is the equal ability to access things. And that's what's been laid bare by this pandemic. And I just want to clarify, this is not going to be our first pandemic. The lessons that we're learning here are not going to be unique to COVID. I frankly believe, and I think the science will show, that we will continue to see pandemics of this nature. They may not just be virus related. They may be related to climates and what's happening, for example, in California, where we've lost an entire town, and what happens to those institutions within that town. So I think that as we have these discussions, we not only have to talk about what the present solutions are, but we have to ask ourselves, are we memorializing how to be flexible for future generations who are going to have to encounter this on a much more regular basis?
Yeah, if I can, Judge Galvan is correct, and I want to make sure that that is clear. Washington courts never closed. We just moved to a different platform, but never closed. Some actually still held in-person hearings and court proceedings. But for example, at the Supreme Court, we've never had in-person hearings since I've been there. So I'm the virtual justice. At the end of the day, though, what COVID also showed was the our courts in Washington State are not up to par. And the Temple of Justice, for example, doesn't have a good HVAC system. I mean, it's been there for years, and COVID showed us that the system within the courts couldn't even keep us healthy as judicial officers. And many other courts found that out as well. So it wasn't just our service to people, it was the service to the employees within these structures that there were problems. But our courts continue to work. Oral arguments at the Temple of Justice continue. I've had many oral arguments. I think I'm going into my 3rd or 4th term of hearing oral arguments starting September. So it's really important that it's very clear. Our court system never shut down. It just moved to different platforms throughout the state. So access to justice remained in place as best as we could.
Thank you this is Carrie. Thank you for clarifying that. And there's such a patchwork in the experiences that came up for people. And then I'm just thinking about what you said, Judge Galvan, that, we're talking about defendants in the criminal justice system and what that looks like to come to court and the risk that's there. And I know issues came up for jury duty too. So I was overly inclusive in my comment. It was really helpful to hear from both of you about what it looked like. I know it was still going, but how it went.
This is Leah. Thank you all. Shifting slightly from COVID centered, though I think right now everything is related to COVID. There is significant and growing evidence that people of color with disabilities are disproportionately likely to be arrested, and that a substantial portion of our prison and jail populations have disabilities. So the question would be to Justices Whitener and Judge Galvan, how should the judicial system account for these disparities? Let's see.
We should acknowledge first and foremost that they exist and then try to address them. But acknowledging first and foremost they exist, this is what I was talking about, that you have to address the race issue before you get to addressing anything else. And a few years back, Judge Galvan and I presented a number of times, but one of the presentations, she said something, and it was so profound in that I believe it was a white colleague of hers said they were leaving a package outside their door for her. And her position was, I'm not picking that up because anybody seeing this brown person going up there to pick that up would probably call the police. People need to understand why race is important in addressing some of these issues. And I point this out with my experience because a few months ago, white male colleague said he had a difficult time seeing me as marginalized and wondering, what I was trying to say because I couldn't be marginalized. And I answered rather simply. I said, yes, I am Justice Whitener. And yes, when I'm doing my job, you see me in a black robe, but at the end of the day, I take that robe off and I maneuver through this world in black skin. So you and I walking into a store, someone will follow me, probably not you. If I go to pay with a check, someone will probably ask me for identification, not you, or credit card, not you. When I drive my car and the cop pulls me over, I have certain things I have to do that you will never have to do. So first and foremost, we need to acknowledge that there is such a thing as racism and other isms, but racism is at the core of these things. And in addressing the issues that are profound throughout our legal system, you're talking about traffic tickets that affect us. You're talking about the way we are seen, shackling in the courtroom. I wrote an opinion on that when I first got to the Supreme Court, how dehumanizing some of these things are. Not acknowledging someone with a disability and removing them from jury service without even trying to figure out what accommodations are appropriate. We have a number of issues, a myriad of issues within our system, but at the end of the day, we first need to acknowledge it. I may not have even answered your question, but that just hit me.
I completely agree with Justice Whitener. I think it's so uncomfortable when you point it out to people, and I have pointed it out to folks in the context of 3.2, which for the last, frankly, 3 years, all I've made is release decisions and bond decisions, and trying to explain to people that the way that I analyze something before somebody's been convicted of a crime is very, very different than somebody who's post-conviction, because our principles say that you're not supposed to be in custody if you haven't been convicted, that you're not supposed to be punished prematurely. Those are our principles, but our practices have been very different. And certainly you can consider definitely certain things, but some of the arguments that I've heard, I've actually pointed out, or in writing, why did you ask for bail with this person with no criminal history for the same type of incident and very similar fact pattern, and ask for so much, half the bail for this person who actually has a criminal history? And the only difference I can see is that one is African-American and the other is not. These are the perceptions. If I'm looking at this perceptions and seeing that, I'm asking for an explanation, because I think that if you're going to, when you have significant discretion and power, you should be explain why you're making the decision that you're making. It should not just be rote. Every individual who comes before you is different. There is something about their life. There's something about their experience that makes them different. And they deserve an individuated assessment of what they are going to do, not some rubber stamp, not some standardized, this is what we do in all of these cases. Because the fact of the matter is even when people say they do that in all those cases, they really don't. It's very subjective. And when you ask people to explain some of their subjective reasoning, it's not based in the law, it's not based in logic. But I think as a judicial officer, when I see it, I point it out. And it makes people so uncomfortable. That's the other thing. We have to be willing to be uncomfortable. I tell people, just because I teach about bias, just because I talk about racism, doesn't mean that I'm comfortable with racism. It's the most uncomfortable thing that we have to experience on a daily basis. I don't get to shut it off when I unzip my robe. I don't get to unzip my skin, as Justice Whitener said, when I walk into a store, or when somebody hears me speaking Spanish and wonders where I'm from, where I'm sitting on a bench and I've been asked by people where I'm from. I mean, those are as if somehow my experience is so un-American, despite 4 generations in on my mother's side. Those are all things that we have to deal with daily, and they are uncomfortable. So I have absolutely no qualms lending my discomfort to others as they try to explain what they've said. And I rarely share anecdotes, but I'm going to share this one. I had a situation in which somebody was asking for extraordinarily high bail for a young man who's charged as an accessory to a very serious crime. This young man was not the principal, no history, honors student, computer science at the local community college. The principal actor was a friend of theirs, and the allegation was essentially that they had driven a vehicle or driven the person after the commission of the incident. Now, the argument was that despite his lack of criminal history, he obviously had friends and family who had all of this. And I looked at the prosecutor dead on, having grown up in a family that had some legal challenge, that was legally challenged or lawfully challenged in some instances. And I looked at her and I go, well, under that standard, I wouldn't qualify for a personal recognizance. And it was, a shock to the prosecutor that I would just say that. If the standard is the neighborhood I live in, the family that I have, and the friends that I make, not my own actions, how many of us wouldn't qualify to be considered to be released to return to court on your own? And that's what we can do as judicial officers. I think that we have a unique opportunity when things come before us to really question why they're there, how they're there, and to make decisions that are based upon our principles. And those are hard decisions. It is hard explaining sometimes to a victim of a serious matter why the decision that I make now is not put him in jail for the rest of their lives. no matter how heinous the crime, I have to hew to our principles. And that's a hard choice every single day. It's soul crushing at times. But it's a choice that I took on when I swore an oath to the Constitution, not to popular opinion.
And Leah, in regards to disability, and I'd like to hear from Carrie on this as well. It appears to me that when it comes to our courts, instead of taking a proactive stance to disabilities, we take a reactive stance. We wait till something happens or it's brought to our attention before we address, as an entity, disabilities. And I'm curious if Carrie had anything to add in regards to this.
Thank you. This is Carrie. So I think there are several components to it. So I agree that we wait and we ask for accommodation. Does someone need this? Does someone need that? Do we have someone who evaluates whether that's reasonable? I, for example, among my disabilities, have an autoimmune disorder, and I was called up for jury service. And I panicked because at the time it was going to be in person, and I wasn't sure what the ventilation would be. I'm in Seattle. And I got rejected for my request, and then my request was honored. I didn't know what was going up, and I didn't want to have a bench warrant out, right? Or I didn't want anyone to try to come and find me either, because I really was hiding out in my basement. I didn't, have that. But I am able to speak in the language of that, understand what is required, consider what the risks are, have a healthcare team around asking for an accommodation. What I've seen play out, though, when I think about, so there's a piece of, we have jurors or we have attorneys coming into our courts. I did a study of attorneys with women attorneys with disabilities, mostly women of color, the way in which judges and court personnel interacted with them was appalling at times, especially if they were women of color. A Black blind woman was called one of the Supremes, as in the music group, not as in a compliment about, being a Supreme Court justice in the state or at the federal level. And so others were questioned about whether they were really attorneys. A common theme that came out was our clients and judges, actually clients had more positive reviews of their disabled attorney. Sometimes think about us as half attorneys and half women, or half, Latina people. It was just like, I can't wrap myself around your whole identity here and what you bring. And then we think about defendants in the system. And when I was a law professor, I did studies of how disclosing HIV status in courtroom affected criminal sentencing. I did work in North Carolina prisons in the maximum security facility with women, where the court administrator said, or the prison administrator said, we have really no women with disabilities in the setting. Someone we have to read mail for, someone used that roll-in shower that we finally put in. And when I looked and interviewed and surveyed, the real trauma that was there and concerns about how health would clash with success with reentry was devastating, because people knew that their mental health and physical health needs wouldn't be supported. So many of them were non-apparent disabilities. So many women had been abused, in their families and then with partners, and it had led them to that situation. They had experienced trauma while incarcerated and didn't get the best mental or physical health care. And they understood the generational impact. So in our work, we have at the Ombuds office, I have really worked a lot with incarcerated parents who also realize that there's a cycle building up and the trauma that happens to their kids, whether they're in foster care, kinship care, they've just disappeared from their lives. So many of those parents want to be engaged with their kids to really end that, and for their kids to know that they are loved. And there's so many barriers within Department of Corrections for that happening. And then we see what happens in education, where you can track a child, especially a child of color with disabilities, and predict what the outcome might be for them. There are studies that say 40% of our incarcerated population has disabilities. Some go up to 70%. They're largely learning disabilities where we haven't supported kids in feeling successful in reading. Also mental health disabilities and post-traumatic stress, and all things that Then behavior gets read as scary. Then we look at reasons why kids aren't going to school and we think that they're just refusing to, but they have experienced racial discrimination there, or don't feel connected to a trusting adult, or don't feel that trust at all with adults outside of school and within school. And then they start to have issues in the justice system. And like Judge Galvan was saying, that kind of experience gets read differently. And so we have seen kids who have been, put out in the hall for most of the day in preschool or kindergarten. And where does that go? And then we think about police misconduct and brutality, and overwhelmingly, it's at that intersection of race and disability. Who we see as scary or non-compliant in a situation and don't necessarily the context, like whether they're autistic, whether they have a hearing impairment, whether they have a health impairment. And that's why they're reaching for something to share, like, hey, I was just trying my best here. I want to give you some context. And I think that part is extremely, extremely scary and makes people feel quite vulnerable. So we're thinking about, I know I have a sub question here. What's the advice for legal advocates and community advocates to become kind of rolled into this is back it on up. And we have to start early, and we have to make sure that schools are culturally responsive, that people and students and families are connected with the supports that they need, that we understand what behavior is, and that we read it in the same way we would for a white student with or without a disability as we do for a Black student with or without a disability. And all of that feeds in, and we have to have the expectation of excellence and understand what it is, what excellence looks like, and what students need out of school, because it isn't the school system that we've necessarily created. So when I just look back at all of those experiences, I didn't start in K-12 education. I've been in this for 6 years. I've had to kind of keep up with that. I started in civil rights law, and one of my first cases was a case of police brutality in Washington, D.C., where I had to depose police officers that were referring to themselves on email as the butt boys because they were doing anal cavity searches of young Black men who were just hanging out at night. And most of them had developmental or intellectual disabilities. So I will never forget that piece of why would you ever put in email or have a sense of pride or name yourselves when you're doing such a violent thing to the people you've identified as most vulnerable and most unlikely to have counsel. And, the stories of education that those young men had pretty much track not being engaged after kindergarten and always feeling like others in the classroom or communities lived in fear of them. We're just waiting for them to become the person that they could send away or read behavior differently. So it is all connected. Back it on up really with all of that.
This is Leah. Thank you all. And I think we have time for one question if from the audience. I'm not sure how to, I think we had a couple people with raised hands. Okay.
Question in the chat as well that's been there for a while. The that has 3 likes, so apparently 3 people want it answered. I don't know if that's been answered.
All right. I did not see the one in the chat. I was told there was one, but I couldn't.
Or in the Q&A.
Oh, in the Q&A. Okay. Yes, I see that now. Okay, let's go with. So Washington courts and schools are set up around local control. And there has been a lot of variability in the ability or willingness of local officials to meet people where they are. Is local control a barrier to equity and access?
I think it depends. I think we have to respect that, communities are different and that they have their own values, their own practices and things, but you can respect that and still require people to meet certain standards of access, particularly for people with disabilities, or ensure that people are able to have the same opportunities provided. And that ultimately is what it's about, is to meet people where they are. So the opportunity that's provided may look different, but it's at least an opportunity to obtain the same result. So I think that we see that in court systems as well. The justice that you may receive in King County or the access to that justice may look very different than, say, in Okanagan. So we have to acknowledge there's a balkanization of technology, a balkanization of systems that people use in our courts, and that has caused some significant issues. We need to be more in step as well and honor and recognize tribal jurisdictions and the work that they do and respect that work. They are judges. They are doing the work of justice. And I know that we have a wonderful tribal state court consortium that's working on ensuring that we have those partnerships, but we need to uphold them as fellow colleagues, fellow judicial officers in this work, and value it as much as we do any of our state courts. So I think all of that is depending. So I think we do need to agree on standards statewide that everybody has to meet and allow for some local decision-making on some issues.
This is Carrie. I think our schools need to be grounded in communities and be responsive at that level, thinking about education. One thing that's really hard, we wouldn't want school districts to decide if they were in a particular community where racism wasn't recognized as existing, that was okay. And we know that federal laws would kick in and state laws, but it's a little bit harder to kind of deal with that if they say, well, this is what access and inclusion look like here, and expect that someone will pursue legal means to ensure that there's a better process and outcome. It was really confusing, and that's an understatement, for how parents could navigate systems and what it looked like. It was really confusing for our office. We didn't know which end was up and where, and because it was a patchwork of decisions outside of the executive order, when we started opening up in person in different ways, and some people staying remotely, some services for special ed or English language learning being transferred elsewhere, it was really, really hard. I think what comes up here, though, too, is with local control is well aware at the state level at OSPI, in our office, when districts aren't being compliant. And it's much harder to grab that when you are not really in an enforcement position, where it looks like you have to take other complaint measures, escalate it to the U.S. Department of Ed or the Human Rights Commission or something like that. So it's harder to grab in that way if it's more an advisory power in most situations.
Do you want me to ask on time? Do we have time for one more question, or?
I think Mr. Eklund has a question.
Yeah, I was gonna. Mr. Eklund, if you want to come off mute.
This is Carrie. I see that the hosts have said Pat was given the ability to ask a question on audio.
Well, we've given Paul microphone rights if he'd like to ask his question. I see Skylar has raised his hand, so I'll go ahead and go there. Oh, who lowered his hand. You can just go ahead and take the second question, and there's about 2 minutes left, so if you have closing comments as well.
Okay, the second question in the Q&A was, do you have any thoughts on race and disability discrimination and its collision with exclusionary zoning that prevents marginalized people from accessing communities of opportunity? What, if any, place do we as legal actors have in this?
I perhaps am not understanding the question. I'm think it's akin to redlining essentially, but with an ableist tendency. Is that correct? Can somebody respond to that? That this is what we've seen for generations in terms of redlining, in terms of where we allowed African Americans, people of color, BIPOC individuals to purchase housing, to accumulate wealth, to generationally pass on that wealth, and the tangential opportunities that come with the ability to leverage that wealth for educational purposes, to buy even more property or to grow capital. I think we see that in marginalization in a variety of different areas. And I think that we need to acknowledge that that's the case. And I think we're more aware now that even things that look neutral on their face can have extraordinary, disparate, and discriminatory results.
Thank you all. And yeah, I think we are at time now. So thank you to all of the panelists. I don't know if there is anyone, there are any closing remarks, or we are finished. But thank you all.